Greetings and welcome to Creation of Express Trust, Manifest Intention of the Settlor from American Jurisprudence. So let's get right down to it. We're going to be reading from, let's see here, this is a January 2023 update. So this is pretty current stuff, and I want to skip down right to the part we're going to get down to, which is, of course, the Express Trust. And if you want to see more about these trusts, we also have some other episodes within the AmJur playlist going over trusts in American jurisprudence. And here's where we start on section 17, general nature of express trust. Before we get started, I just want to remind everyone that this is a educational informational broadcast, not to be used for any kind of professional, legal, lawful, or otherwise use other than the intended educational entertainment use here on YouTube. Don't do this at home. All right, let's proceed. And if you just showed up, give me a heads up in the chat so I know that everything's coming through loud and clear. And we're going to get started. Okay, so section 17, general nature of express trust and distinctions. Express trusts, which are sometimes referred to as direct, technical, or voluntary trusts, are those trusts created by the manifest intention of the settlor, or the grantor, right, to create them. Express trusts depend upon intention, as distinguished from implied trusts, such as constructive or resulting trusts, which arise by operation of the law, or upon fraud or wrong, irrespective of the intention of the parties concerned. Thus, it may be said that an express trust is created by the direct and willful acts of the parties, some writing or deed, or words expressly evidencing the intention to create a trust, while a resulting trust is one arising from a presumed intent of the parties at the time title is taken by one party under facts and circumstances, showing that a beneficial interest in real property or personal property is in another. And a constructive trust is a duty imposed by courts of equity to prevent the unjust enrichment of a holder of title to property which the holder acquired through fraud, breach of duty, or some other circumstance making it inequitable for him or her to retain it. So, we're already going over a few here, so we're talking about express trust here, and it's intention of the parties, right? It's a willful act, and it's expressed, it's evidenced by the words expressing this intention. And let's see, while resulting trust is one arising from a presumed intent. So we have an express as opposed to a resulting trust. And a constructive trust is a duty imposed by courts. So let's continue. A valid trust does not arise from the mere action of a moral, ethical, or honorary obligation or trust. An honorary trust is not a true trust, since an honorary trust does not conform to the time-honored requirement that there be a beneficiary capable of enforcing the trust's terms. Okay, so that's one aspect of validity of a trust. Can the beneficiary enforce the terms of the trust? So let's continue here. We have some citations here. Under Kansas law, a technical trust differs from an express trust in that the intention of the parties is not relevant. The parties' fiduciary obligations are imposed by law and not implied by law. So, note for Kansas. An express trust is one in which circumstances show that the grantor of the property intended to create a trust. As to trust arising by operation of law, see sections, we're not going to go over that today, and creation of trust is discussed more fully in the next section we're about to go to, and a trust in realty given by a mother to her son is not created by her statement of her desire that the proceeds of the property, if sold, shall go to designated persons. All right, let's continue here. So let's get right down to Section 18, Creation of Trusts. And I'm trying to make sure the chat's working here so I can get some. Oh, here we go. Now it's working. All right. Why wasn't this coming up before? There it is. All right. Apero, greetings. Captain Jack, welcome aboard. All right, let's continue. All right, so we're on to Section 18, Creation of Trust. Except as prevented by the doctrine of merger, a trust may be created by, all right, take notes here. Number one, a transfer by the will of a property owner to another person as a trustee for one or more persons. Two, a transfer inter vivos by a property owner to another person as trustee for one or more persons. So, in between living entities here by a property owner to another person, right? Let's see here. Number three, a declaration by an owner of property that he or she holds that property as trustee for one or more persons. This is an interesting one here. Declaration by the owner of a property that he or she holds that property as trustee for one or more persons. Take note, he or she, and over here we have persons. Why didn't they just use persons here, right? Because when they say he or she, they're referring to a living man or woman. 4, an exercise of a power of appointment by appointing property to a person as trustee for one or more persons who are objects of the power. So this is an interesting one here. The exercise of a power appointed by appointing property to a person as trustee. Wow. An exercise of a power of appointment by appointing property to a person as trustee for one or more persons who are objects of the power. Or 5, a promise or beneficiary designation that creates enforceable rights in a person who immediately or later holds those rights as trustee, or who, pursuant to those rights, later receives property as trustee for one or more persons, beneficiary, right? An express trust is generally created in one of two ways. Here we go. Number 1, a declaration of trust by which the owner of property declares that he or she holds it as trustee for some beneficiary. Or 2, a transfer in trust by which the owner transfers to another as trustee for some beneficiary, either by deed or by transfer intro vivos or by will. So let's read this again. Generally, right? An express trust is generally created in one of two ways: a declaration of trust, right? Or a transfer of trust. Practice tip. This is one of the nice little perks of American Jurisprudence. We get some nice little practice tips in here. The recommended practice for establishing a trust is to execute documents of transfer along with the declaration of trust as the transfer documents help to prove that the settlor intended to create the trust. Remember, it's all about the settlor's intent. So recommended practice, and wouldn't hurt to do this, right? Just making sure that you have clear evidence that the settlor intended to create the trust. A testamentary trust must be executed with the same formality as a will. A transaction failing as a gift may give rise, irrespective of such failure, to a trust, where it complies with all the essentials and requisites of a trust. An express trust may be created even though the parties do not call it a trust, and even though they do not understand precisely what a trust is. Now that's interesting. It can be created even though the parties do not call it a trust, or even though they do not understand precisely what a trust is. There has to be some element, but not precisely, right? So this is interesting. So a transaction failing as a gift may give rise to a trust, where it complies with all the essentials and requisites. So intention, right, is the main one here. Having it written express trust may be created even though the parties do not call it a trust. That's interesting. Moreover, the converse is equally true. Just because the parties deem a trust into existence does not necessarily mean they created a trust. In some instances, an express trust may be affirmatively created and declared by a court, as for example, where created by a divorce court to secure payment of alimony or child support awards. However, a court may impose a trust when none exists to effectuate the parties' intent. A court cannot impose a trust where parties have contemplated another relationship. So that's something to have here. The observation: once established and acknowledged, a trust does not need to be constantly reiterated or confessed. They talk about the impenetrability of a trust. So once it's established and acknowledged, it does not need to be constantly reiterated or confessed. So very good stuff here. See if this chat's working still. Indeed, it seems like it might be. And let's see here. Evidence, express trust is created by terms of will, deed, or other writing or arising from direct and positive action of parties as evidenced by written instrument. So this is an important one here. It's only since 1995. So it's created by terms of will, deed, or other writing, or arising from direct and positive action. So not being negatively affected, this is something positive to be created, right? Positive action of parties, and it's evidenced, so the court will recognize this by the written instrument. And the nice thing about express trust is that you have that kind of weight of evidence here of the written instrument. And as the old maxim goes, the spoken word flies, The written letter remains. As to methods of creating trust, see Section 18, which we just went over. A trust will not be created where none, in fact, was contemplated. All right, now we're on to Section 19, the purposes of trusts. A trust, to be valid, must have a purpose. The purpose of a trust governs its administration and enforcement, and such purpose is determined by examining the language of the trust instrument and the surrounding circumstances. In the absence of a statute to the contrary, a settlor may create a trust for any lawful purpose, and the trust may be created for the settlor's own benefit as well as the benefit of another. Interesting there. The material purposes of a trust are subject to the settlor's discretion, which is limited only to the extent its purposes are lawful, not contrary to public policy, and possible to achieve. The Uniform Trust Code, which provides that a trust may be created only to the extent its purposes are lawful, not contrary to public policy, and possible to achieve, also adds that a trust and its terms must be for the benefit of its beneficiaries, and also provides that the requirements for a trust creation, including the requirement that a trust have a legal purpose, are controlled by statute and common law, not the settlor. Interesting there. Now, let's look at this observation here before I continue here. So the UTC, the Uniform Trust Code, provides a trust may be created only to the extent its purposes are lawful. That's one, not contrary to public policy, which gets to our legal stuff here, and possible to achieve. Again, the beneficiary has to be capable of enforcing the trust. That's one possibility there that needs to be contemplated. Also adds that a trust and its terms must be for the benefit of the beneficiary. So there's an also adds, I would assume this is and also provides that the requirements for a trust creation, including the requirement that a trust have a legal purpose. So not only has to have its purposes are lawful, right? But it must also have a legal purpose. Interesting. Are controlled, and that's going to be controlled by statute and common law. So the requirement to have a legal purpose is controlled by statute and common law. And any lawful purpose is up to the settlor as long as it's lawful, it seems. Limited then by which state it's in and the statutes. And okay, that's it. No other tips here. Let's see what we have here as a construction of trusts generally. See sections 28 to 39. As to trust contravening law or public policy, section 20. So we get 28 to 39 because I believe after this section we're coming to, contravening public law or policy. We need to go over this one. Section 20, trust contravening law or public policy. Let me get to the chat real quick here. Captain Jack, one thing I must say, there's no such thing as case law. We have case citations that are at the end here, but this is already pretty straining on the attention. So I'll leave that for the readers or the listeners to go back and read those citations if they're so interested to that. But I'm reading the footnotes that come along with those case citations there. But remember, the laws are the ones that are created by Congress and not the judicial branch. But yeah, the case citations can support arguments in law, but they are not the law. So yeah, I just want to make that quick clarification there, if I may. And Those are at the end there. I'll point them out again as we come to them for this section here. A trust must have a lawful subject matter. A court's primary duty in construing a trust. So the court's primary duty in construing a trust is to give effect to the trustor's intent, so long as such intent does not conflict with the demands of law and public policy. Generally, where the object of a trust is to circumvent a statutory prohibition or defeat a public policy, the trust is void and of no effect, and one who wishes to dispose of his or her property through the device of a trust must do so subject to the considerations of policy. Oh, geez, that's flat out letting you know. And a person cannot force the courts to sanction his or her scheme of disposition if it is inimical to the interests of the states. All right, you got me here. Inimical, and I don't know what that means. And we're going to go now to Black's Law and find out what it means. Bear with me one moment. Let's zoom in a little bit so we'll be able to read this thing here. It is a scanned document, so I have to can't search it. We're going to have to hope it brings us close by, and then I can scroll. Well, domicile established by physical presence within a state or territory coupled with the intention to make it home. Domicile that a person chooses after reaching majority or being emancipated. Yikes. Okay, let's see, it's back. All right, we're almost there. H, yes, almost there. I already forgot how to pronounce the word. Where did it go? Inimical. Okay. Almost there. We're working there. Jeez, here we go. Here's incapacitated. Oh, there's INC ones, huh? Oop. Passed it. How did I pass that? Did they not have it in here, or did I miss it? We haven't got to. Oh, I see. We're inside of another subcategory of another word. See, I don't have headings on all these. Wow. All right, thanks for bearing with me, whoever's still here. This is why I like paper documents. They're so much easier to flip through a book. There's some of the indexes are at the top here, but not all of them. Oh, index. Oh, serendipitous. All right, come on. I think we could have Googled it faster than this. All right, here we go. Oh, missed it. I just swept right by it, didn't I? Well, I don't see it, but inimicus, deadly enmity. Well, all right. Enough of that. So it's not Black's Law. So this is just a regular word that I don't know that we all could probably be good to know. Let's see if we can pull up a quick. Oh, this isn't gonna be quick, guys. It's in the eyes. Yeah, it's not in there. So we're gonna pull up. No, we are gonna actually do the wretched thing. We're gonna have to do a Google search. Yeah, tending to obstruct or harm. Okay, that would have been a lot quicker. We won't do that again. Yeah, okay. My apologies. Let's get right back to the subject here. It follows that criminality of purpose ordinarily voids a trust. So, however, the illegal motives of a trustor, where his or her method is legal, do not generally affect the validity of a trust, although certain motives, such as evasion of taxes, may cause the court to resolve doubts against the trustor. Interesting again. Furthermore, a trust executed by illegal means need not fail if the trust could have been executed by legal means without defeating the settlor's purpose. Wow. So it sounds like there could be even a revision if there was some illegal element that could be made, could be executed by legal means. Oh, okay, so execution by legal means without defeating the settlor's purpose. Footnote 7, that looks like an interesting case to look up. The view has been taken that public policy is not violated by a trust provision for loss of any benefit under a testamentary trust under adoption of the beneficiary by a non-member of the testator's immediate family. So inheritance stuff here, that gets a little complicated. You can reread that. Caution. This view has been expressly rejected where a codicil, which added a condition to a will that if particular persons were named and appointed and acted as either the guardian of the person or the guardian of the estate of any beneficiaries of a trust for children, all funds and all property held in trust for the beneficiary would revert and become part of a trust for a different beneficiary. It was deemed void against public policy since it sought to forfeit the estates of minor children because of an action taken by the probate court in their interest. Oh, gosh. So be cautious. So footnote 7 is one National Bank of Commerce versus Greenberg, 1953. Excellent. Impossibility of performance. This is one of the important requirements, so we're definitely going over this one. Present impossibility of performance of a trust, or the impossibility of a particular mode of performance, does not necessarily prevent a trust from arising or call for termination of a trust, at least where a deviation from the terms of the trust in order to accomplish the ultimate purpose of the trustor under a decree or order of the court is justified. Impossibility of performance works a failure of the trust, however, where the performance is material to the very existence of the trust and where no justifiable deviation from the terms of the trust can be made a modified performance possible. So, impossibility of performance works a failure of the trust. But where the performance is material to the very existence of the trust and where no justifiable deviation from the terms can make a modified performance possible. So that takes a lot to show impossibility of performance. I guess it would have to be a poorly expressed trust. And here are some of the ones here: modified other grounds. You don't want to have to be modifying for impossibility and things like that. And effective provision for forfeiture by contesting beneficiary. No contest clauses. A trust instrument may validly provide for forfeiture of the rights of any contesting beneficiary. Further, it has been stated that a no contest clause in a declaration of trust is valid and must be given effect according to the intent of the trustor, as that intent appears from the terms of the instrument itself and surrounding circumstances, as we spoke earlier. But here's our student observation here. Although a no contest clause in a trust is enforceable, it will be strictly construed. And no contest clauses in inter vivos trusts are not to be extended beyond what was plainly the settlor's intent. A forfeiture provision of a trust is to be enforced only where the trustor intended that the beneficiary's conduct should forfeit the beneficiary's interest under the trust agreement. Whether there has been a contest within the meaning of this particular no contest clause depends upon the circumstances of the particular case and language used. Again, we're back to the express of the trust, the language used. And here's a cumulative supplement: cases. As in other areas of law, a will or trust provision seeking to sustain forfeiture is construed strictly against forfeiture, and thus the instrument must give the right of forfeiture in terms so clear and explicit as to leave no room for any other construction. Okay, so there it is. If there's going to be a forfeiture clause, it better be loud and clear. All right, we have as construction of trusts, as the effect of a provision for forfeiture by contesting beneficiary in the case of wills. Generally see wills, but we're not going to get into that detail of the trust. Okay, now we get into multiple trusts and all that good stuff. We can skip down here though to 28. I think there might be something else that still apply to our topic for this evening. General Rules of Construction, Section 28. Let's go over this briefly and then we'll continue. In general, the rules for construction of written instruments apply to the interpretation of trusts, so that the meaning of the trust instrument is determined by the same rules that govern the interpretation of contracts, deeds, or wills. In construing a trust instrument, the courts are required to subordinate form to substance. So they have to subordinate form to the substance when they're construing the trust instrument. So again, it doesn't matter though. Contracts aren't trusts or deeds and wills, not specifically, but when it comes down to the written instruments like these, the form. Let's see. Oh wait, subordinate form to substance. I got it backward. Okay, so all right, let's read this again. In general rules. For construction of written instruments apply to the interpretations of trust. The general rules do for the form, right? So that the meaning of a trust instrument is determined by the same rules that govern the interpretation of contracts, deeds, and wills. So it's determined by the same rules, but in construing a trust instrument, courts are required to subordinate form to substance. So they subordinate form to substance, form before substance. They have substance of the trust. Again, the intent will override the actual form. And as we saw, if it could be executed lawfully, even or legally, even if it isn't necessarily constructed that way, it would still be enforceable. All right. Courts apply the same rules of construction as applied to a contract to determine whether the language in a trust is ambiguous. So, okay, that's a specific application there. As to the construction of contracts, okay, yeah, as construction of deeds, it's construction of interpretation of wills. Okay, creator's intent. Section 29. Primary rule of construction for trusts is that a court must, if possible, ascertain the intention of the testator or creator. And a court's primary duty in construing a trust is to give effect to the trustor's intent, so long as such intent does not conflict with the demands of law and public policy. It is said that the cardinal rule of law in a trust case is that the intent of the settlor controls the interpretation of the instrument. And where the purpose of a trust is ascertained, that purpose will take precedence over all other canons of construction. When the purpose of the trust is ascertained, that purpose will take precedence over all other canons of construction. In interpreting a trust, a court's initial focus must be on the terms of the trust. Accordingly, courts look first to the language in the trust and interpret that language to effectuate the intent of the settlor or settlors. It is the grantor's intention. They love jumping the words here, but just keep in mind settlor's, grantor's intention, which exists at the time of the execution of the trust instrument which controls, not one thereafter formulated and not expressed in the instrument. However, the intention of the settlor at the time of creation of a trust may be shown by facts occurring after that time. Circumstances. In construing a trust document, the fact that the form of assets may change over time does not defeat the settlor's intent of disposing of the assets. When words of recommendation must be followed to carry out the clear intention of the settlor of trust, such words are regarded as words of command or direction. Words of recommendation, wow. They are regarded as words of command or direction from the settlor. All right, let's see what footnotes we have here. Unless contrary to settled principles of law, the intention of a trust settlor must control in actions involving the trust. All of the rules of construction must be subordinate to determining the settlor's intent, their value being as aids in ascertaining that intent as precisely as possible. That was 2003. Interesting. So all of the rules of construction must be subordinate to determining the settlor's intent, their value being as aids in ascertaining that intent as precisely as possible. So they could just be aids. Nice. The threshold inquiry in any trust case is to examine the terms of the trust document. So that's your threshold inquiry. All right. And next section here, we're on to construction of unambiguous trusts generally. And let's see how long. This is a nice short one, and we have our observations. It's an important one. If the text of a trust instrument is plain and unambiguous, the intent of the settlor can be ascertained from the language of the trust document itself. So in general, if the language of a trust instrument is clear and it can be carried out as written, there is no room for construction. So yeah, that's a good thing to keep in mind. Do it right on the front end here. Thus, When the language of a trust instrument is free from ambiguity, the resort to parole or extrinsic evidence is prohibited. So parole, to speak evidence, you have someone making verbal testimony, or intrinsic evidence is prohibited. The express language of a trust generally guides the court in determining the intentions of the settlor. Accordingly, the settlor's intention is ordinarily to be gleaned from the four corners of the trust instrument itself, considering the language used and giving meaning to all provisions whenever possible. And collateral evidence will be considered only when there is uncertainty about the testator's intentions from looking at the language of the instrument. So here's our observation. If the court can give a certain or definite legal meaning or interpretation to the words of a trust instrument, it is unambiguous, and the court may construe it as a matter of law. Accordingly, the interpretation of an unambiguous trust is a question of law for the court to decide. And we have cases. Here we go. Any reasons Settlor may have had for not removing his son and his grandchildren as trust beneficiaries after son filed suit challenging trust had no bearing on enforcement of trust in terrorem clause. The trust agreement was governed by the plain and unambiguous language contained in the four corners of the document. Nice. End of that supplement. So where the language of a trust is unambiguous and express the intention of the maker, it is unnecessary to construe the instrument because it speaks for itself. That's nice. In interpreting a trust, the court could not rely on an affidavit of the trust drafter, where the trust language was unambiguous. Wow, in interpreting a trust, the court could not rely on an affidavit of the trust drafter, where the trust language was unambiguous. Barnett Bank. Oh, wow. Okay, this Florida Second District Court Appeals. All right, and that's it for that supplement there. And construction of ambiguous trust. So we're going to look at this, have our contrast from what we just went over here. Where the express language of the trust does not reveal the grantor's intent, the court must ascertain that intent through the use of various presumptions, rules of construction, and a review of applicable statutes and case law. Wow, they even say case law here, huh? They're stretching it. However, technical rules or canons of construction of a trust should not be resorted to only if the language of the trust is ambiguous or conflicting, or the settlor's intent is for any reason uncertain. Rules of construction for interpreting a trust are applied when the language of the trust is not clear, but if the language clearly expresses the settlor's intent, the rules do not apply. The courts turn to parole or extrinsic evidence only if the trust instrument is ambiguous and the settlor's intent cannot be ascertained. When parole or extrinsic evidence is admitted to aid in construing a trust instrument, it may be used only to explain, not to contradict the instrument. Interesting there. Only to explain, not to contradict. It should be noted that a trust document is not ambiguous merely because the parties disagree over its meaning. When a trust beneficiary is described in terms applicable to more than one person or thing, parole evidence is admissible to prove which of the persons or things so described was intended, so to speak. You have the person there verbally give evidence, testimony there. Definitions. Ambiguity in a written trust instrument exists when, in the light of the circumstances surrounding the execution of the instrument, The written language is fairly susceptible of two or more constructions, or where there is uncertainty as to the meaning of a term. While a patent ambiguity is apparent on the face of the trust, a latent ambiguity is not evident until there is an attempt to apply the trust provisions to the existing facts. That's a nice little way to wrap up the ways of approaching the ambiguity, right? You have the different kinds that they're getting here. It's light. See here, the two or more constructions, uncertainty of the meaning of a term, and then there's the patent ambiguity, which is apparent on the face, and a latent ambiguity that's not evidence until there's an attempt to apply the trust provisions to the existing facts. Observation: if trust language is not clear, construction of an ambiguous trust instrument is a question of law to be decided by the court. Remember, if the language is unambiguous, the trust instrument is the law. However, it has been said that once a written instrument is determined to be ambiguous, the meaning of its terms generally is an issue of fact. So, we have a nice cumulative supplement here. Cases. Trust agreement that called for the creation of two trusts after the death of first co-grantor, one of which was to be irrevocable and funded with as many assets as could pass free of federal estate tax, and the other of which was to be revocable and funded with all remaining trust assets. Was ambiguous as to the intended result when the trust assets at the time of the first co-grantor's death were less than unified estate tax credit, and thus extrinsic evidence of intent could be considered. Requirement to fund the irrevocable trust up to the unified tax credit conflicted with requirement to create two trusts and with trust's stated purpose of providing for grantors during their lifetimes. Okay, that's enough on that case. Some of those inheritance cases, make your head spin. Court may be aided in ascertaining the intent of the settlor of a trust by use of presumptions and canons of construction. Wow, the intent by use of presumptions may be aided in ascertaining the intent by the use of presumptions and canons of construction. Again, constructing it the best yourself is the way to go, it seems. Ordinarily, where a trust is silent on a particular question, in the sense that it contains no express answer to the question, then a construction of the trust is necessary. Where a trust instrument contains some expression of the trustor's intention, but as a result of a drafting error, that expression is made ambiguous, the trial court may admit and consider extrinsic evidence, including the drafter's testimony, to resolve the ambiguity and to give effect to the trustor's intention as expressed in the trust instrument. And that was from Ike versus Doolittle. Oral testimony or parole evidence here is admissible only for the purpose of showing the meaning of the words used in a trust instrument when they are ambiguous, and not to show what the settlor intended as distinguished from the settlor's expressed words. Only ambiguity. So you can use that parole evidence only when there's an ambiguity, as we just read. As to the admissibility of evidence regarding trust matters. We're not going to get to that today. And then we have last one here, the rule of liberal construction. Section 32. The law favors the liberal construction and interpretation of trust. Trust should be construed in favor of upholding the validity of the instruments creating them, and to uphold the settlor's intent. In this regard, charitable trusts are regarded by the law with special favor. When interpreting a trust, A court must give effect to the intent of the settlor or testator. So, in construing a trust, the court is limited to establishing what the creator what the creator did say, rather than what the creator meant to say, or stated another way. The court must not read into a trust instrument provisions that do not expressly or impliedly appear from the plain meaning of its words. Accordingly, when interpreting a trust instrument, a court cannot rewrite the trust instrument, and the expressed intent must control, insomuch as substituting the court's discretion for that of the trustee would undermine the intent of the settlor of the trust. Wow. Again, the trust properly constructed is the law, as long as it doesn't, whatever that word was we came by. This is Section 33. Rule that terms be giving ordinary meanings. The meaning accorded to the language used in a trust is to be usual or common and ordinary meaning. In construing the intent of a trust grantor, the grantor is presumed to know and intend the legal effect of the language used. And the court must give the words used in their usual, ordinary, and natural meaning, unless a contrary meaning appears in the instrument. Stated another way, the words used in a trust instrument are to be taken in their ordinary and grammatical sense, absent a clear opposite intention. Words with a well-known technical meaning should be construed according to their technical meaning when determining the intent of an inter vivos trust grantor, unless a contrary meaning appears in the granting instrument. On the other hand, when a term in a trust instrument is undefined, the courts usually look to the clear ordinary meaning which a non-law trained person would attach to the term. Perhaps why I didn't find that other term in Black's Law Dictionary. But I digress. When words of general meaning in a trust are preceded by and connected with words of narrower impact, the interpretation of the words of general meaning is confined to the species of things more specifically described. It has been held that words in a private instrument, such as a trust, are ordinarily, in the absence of a showing of contrary intent, given the same effect as by statute or case law. All right, and that's the end of that section there. And this last one here, I think, is construing document as a whole, section 34. When construing a trust, a court must consider the trust instrument as a whole, considering all parts in light of the entire instrument. All provisions of a trust instrument must be construed together, with every word given effect, if possible. A trust document must not be examined piecemeal, and the intention of the settlor must be determined without taking individual clauses out of context and considering them without reference to the whole instrument. Clearly, then, the intention of the settlor is not to be gleaned from any particular word or provision, but from a sympathetic regard of the trust instrument as a whole. And no single clause or word is to be given undue preference. Further, a court should construe the trust instrument to give effect to all provisions in it, so that no provision is rendered meaningless, and all terms in a trust instrument must be harmonized to properly give effect to all parts of the trust instrument. So leave no provision behind. In examining the entire instrument, the court should give each word and phrase a meaning that, whenever possible, agrees with or accommodates the other. So we want some kind of continuity here in the language. Under the doctrine of expressio unius est exclusio ulterius, meaning the expression of one thing implies the exclusion of all not expressed. So, yeah, this is, if it's not, let's see, the expression of one thing implies the exclusion of all not expressed. The expression of one thing implies the exclusion of all not expressed. The court attaches significance to the differences in the provisions of a trust instrument. I'm trying to think there's another way is if it's not included, it's excluded. Or if it's not excluded, it's included. Something to that effect. But yeah, this is the expression of one thing implies the inclusion of not all expressed. The exclusion of not all things that were expressed. All right. The intent of the settlor in a trust case must be determined by considering the language of the trust instrument read as an entirety in light of the circumstances surrounding its creation. This gets right back to where we started, right? Circumstances and intent. Let's see here. Missing anything here? Yep. All right. All the language of a settlor must be given effect, if at all possible. When interpreting trust language, the court does not read words in isolation or out of context. That was in 2001. Where provisions in a trust instrument appear to conflict, they should read in such a fashion as to give effect to both and or fulfill the intent of the settlor. And now we have to go over this because we need to know about these circumstances. So Section 35, consideration of circumstances surrounding execution of instrument. Where the settlor's intention in creating a trust cannot be divined clearly from the face of the document, the words used must be construed against the background of the surrounding circumstances at the time the trust instrument was executed. Where construction is necessary, a court must pull itself in the situation of the settlor when the settlor made the trust instrument and, from a consideration of the language used in the entire document, determine the intention of the settlor. Accordingly, in interpreting a document such as a trust, it is proper for the court to consider the circumstances under which the document was made, so that the court may be placed in the position of the trustor whose language it is interpreting, in order to determine whether the terms of the document are clear and definite or ambiguous in some respect. To ascertain the settlor's intent, the court may look to the circumstances known to the settlor on execution of the trust. The expressed intent of the settlor is to be determined from a reading of the trust instrument as a whole in light of the circumstances surrounding the settlor when the instrument was executed, including the condition of his or her estate, the settlor's relations to his or her family and beneficiaries, and their situation and condition. Conditions are things that are not absolutely determined, and it could be one way or another. So our observation, each case involving the construction of trust instruments of necessity is determined upon its peculiar facts and the particular instrument to be construed, all to the ultimate and primary end of effectuating the settlor's intention. Beautiful observation here. I'm going to reread this one because this should really stick in. It kind of brings everything together here tonight. Each case involving the construction of trust instruments of necessity, construction of trust instruments of necessity is determined upon its peculiar facts and the particular instrument to be construed, all to the ultimate and primary end of effectuating the settlor's intention. Where there are two or more instruments relating to a trust, instruments should be construed together to effectuate the settlor's intent. Accordingly, instruments including trusts executed at the same time by the same party for the same purpose and in the course of the same transaction are one instrument and will be read and construed together as if in one form. So they have the same form. Substance and form, and they will be just considered one form. All that substance there. So let's see what we got here. Court of Appeals may always receive and consider. All right, we're back. That was weird. Okay. Where the will and trust agreement form a part of the same estate plan, they must be construed together. Okay. We're going to leave it at section 36 here. Now we're getting down to the stuff where we'll look over this practice tip because this is always a good one here. But determining what law was in force at the time a legal instrument, such as a trust, was executed. A court assumes that the testators know and understand the meaning and effect of the terms used in a trust as defined under state law. Interesting. So, if you wanted to redefine a term that's used in state law under the terms of your trust, where would that fit in? Is the question. There's a presumption that if the beneficiaries in a class are identified over a period of time, the grantor intends that changes in the law subsequent to the execution of the trust be grafted onto the provisions of the trust. Wow. All right, let's read some of these footnotes here. One, executing a trust and distributing. Let's see here. What do we miss here, though? We just in construing, the provisions of the trust are to be governed by law in effect at the time of its creation. Not the law and public policy in effect at the time the construed words will take effect, absent a contrary intention within the instrument itself. Again, wow, that's great. Let's see what these citations they have here. One, executing a trust and distributing property thereby is entitled to rely on the law in effect at the time the instrument was created. In the YouTube verse. All right. Looks like we're getting back online. Wow, that was really strange. Okay, we're back here. All right. One, executing a trust and distributing property thereby is entitled to rely on the law in effect at the time the instrument was created. The language of an inter vivos trust should be construed according to the law in effect at the time the trust is executed. Trusts that specifically stated that it was intended to be given effect and in accordance with the present existing laws and statutes of the settler's resident state had to be interpreted using law in effect in settler's state at the time the trust was executed. See, the trust makes the law. Wow. All right, so that was worth, for anyone that's still here, that was worth sticking around for. So trusts that specifically stated, look at the, even give the language, given effect, under, and in accordance with the present existing laws and statute of the settler's resident state, had to be interpreted using law in effect in settler state at time trust was executed. Beautiful. I mean, that's the intent, of course, because it's all about intent. We're going to leave it at that at section 37, conflict of laws, because I think we know where this is going. And for future broadcasts like this, please subscribe and make sure you get the notification bell hit, because that's the best way to know if indeed we are going live, because I know the notifications can be a little bit thin these days from channels like this trying to push information that might help you open up to some other courses of learning. That being said, I want to thank everyone for coming out and joining me with this expedition down the American Jurisprudence creation of express trust and get into the details about the manifest intention of the settlor or the creator of trust. That I salute you all for sticking around and learning about this, a very valuable part of our American heritage. And as the posterity, it's up to us to uphold for the future generations and posterity in this country. So salute to you all and peace out. I'll see you all in the next one.